Hello and welcome to Unacademy. It was in November. The Punjab cabinet, headed by its chief minister, advises the governor to summon the budget session of the Legislative Assembly. The governor refuses. Matter reaches the Supreme Court. Supreme Court clarifies that summoning the Legislative Assembly is not a discretionary power of the governor, it is the prerogative of the state cabinet headed by the chief minister. 2016, the cabinet of Arunachal Pradesh government advises the governor to summon the Legislative Assembly in January. The governor prepones the Legislative Assembly to December. Matter goes to the Supreme Court, and Supreme Court clarifies that the governor can summon the Legislative Assembly only on the advice of the Council of Ministers headed by the Chief Minister. In Tamil Nadu, 10 bills were passed by the Legislative Assembly, sent to the governor, because without the governor's signature assent, these bills cannot become laws. The governor is sitting on these bills. Some of these bills have been reserved by the governor for the consideration of the president. Matter goes to the Supreme Court. And in April this year, a landmark judgment was given by a two-judge bench of the Supreme Court. Supreme Court invoked Article 142, which is the power of the Supreme Court to give complete justice. And Supreme Court said this decision of the governor and the president is erroneous and called deemed assent, which means even without the explicit signature and assent of the governor, these 10 bills became laws. And for the first time in the history of independent India, 10 laws came into force without explicit signature assent of the governor. There is a conflict, a tussle between the democratically elected chief ministers and the appointed governors in states such as Tamil Nadu, Telangana, Karnataka, West Bengal, Punjab. And if you notice, there is one thing in common. All these states are the opposition ruled states. That means the government is run by a political party which is in opposition to the ruling political party at the center. Because the governor is the nominee of the ruling political party at the center. The governor is appointed by the president on the advice of the prime minister, and prime minister is the leader of the ruling political party at the center. This raises a larger question. Is it time to abolish the office of governor? And that's the key question that we will be addressing in today's session. What are your thoughts? Do let me know in the comment section. And before we start, an important announcement. If you are preparing for the civil services examination and if you want coaching to comprehensively cover your GS and CSAT syllabus, then I urge you to join our Ignite batch, where through live classes, through weekly tests, through mentorship, we guide the civil services aspirants. Go to our website, check various options. You may see whatever price being quoted on the website. But if you apply this code IAS English, you will automatically unlock a 60% discount on our UPSC subscription. So let's get started. But first up, let's look at what is the constitutional provision with regards to the governor. Article 163 says there shall be council of ministers headed by the chief minister to aid and advise the governor, who shall act on that advice. That means the advice given by council of ministers headed by the chief minister is binding on the governor, except when the governor has to act in his discretion. That means except in those circumstances where the governor is not bound by the aid and advice of the chief minister and council of ministers. But the problem is, what are these discretionary powers of the governor? These have not been mentioned, codified, elaborated, clarified in the constitution. But constitution does say that if at all there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final, which means, long story short, the governor of a state gets to decide what are his discretionary powers. To understand this office, we need to understand the origin of this office. Remember the Government of India Act 1935, which established provincial legislative assemblies in the states. People will vote to elect their representatives in these legislative assemblies. And then this legislative assembly will make laws, will pass bills. But these bills need the signature of the governor. And the governor was appointed by the crown, British crown. So this governor would block a bill if it is against the British crown, against the interests of the British crown. So this governor, under the Government of India Act 1935, was the agent of the British crown, was not a democratic institution. And we saw how governors would block the bills passed by these provincial legislative assemblies. That is why when constitution was being drafted, when the Constituent Assembly met to draft and enact the constitution for the independent India, there was a debate as to whether we should continue with this office of governor or not. There were some in the Constituent Assembly who were in favor of retaining the office of governor, but there were others who were completely critical of the office of the governor. Someone like Mr. K.T. Shaw, the member of the Constituent Assembly, he said that this governor would be biased in his functioning, and his functioning will be at odds with the popularly democratically elected governments. That is why we should not have the office of governor. We should not retain this office of governor because now we are an independent India. And as an independent India, we should not have an appointed individual block the bills passed by democratically elected legislative assembly. But when the constitution was enacted, the office of governor, the provisions related to the office of governor were exact replica of the provisions in the Government of India Act 1930. Because there was a consensus in the Constituent Assembly that we need this office of governor. And why? There were two important reasons given. One, there is a dearth of competent legislators in the states. In the states, when legislative assembly would meet, MLAs would get elected, maybe they will not be in a position to pass good bills. And to ensure that these bills are fair, reasonable, we need somebody who is appointed by the center to keep a check on the bills passed by the legislative assembly. Because there is a dearth of competent legislators in the state. And second reason given was certain amount of centralization of power is necessary. Because let's not forget, although we got independence in 1947, but with a cost. And the cost was the country was partitioned, unfortunately, on the grounds of religion. India and Pakistan, two countries were born. And the makers of the constitution, the members of the Constituent Assembly, they were wary that we need somebody who can keep a check on the Legislative Assembly so that we can have some amount of centralization, so that international bills or those laws which are against the unity, integrity, sovereignty of the nation should not get passed, should be blocked by this appointee of the center. So, long story short, two reasons were given why we want to retain the office of governor. Number one, there is a dearth of competent legislators in the states, and a certain amount of centralization of power is necessary. But then, Constituent Assembly retained the office of governor, but thought that this governor would be only a constitutional head, a ceremonial head. The real power will be with the chief minister and his council of ministers. The governor will only be a nominal constitutional ceremonial head who will uphold the constitution in the state, so that in these states constitution is not violated because constitution is supreme. Second, to maintain federal balance, because we are a federal polity, and in federal polity there is distribution of powers between the center and the state. There is dual government, one government at the center, the government in the states as well. To maintain a link between the state and the center, we need this appointee of the center in the state, and the office is of a governor. And third, assist when there is a political instability. For example, in Manipur right now, there is no popularly elected government in place. And the government in Manipur is being run by the governor of Manipur. And this governor is appointed by the center. So, in times of crisis, political instability, we need somebody to run the affairs of that state, and that individual is the governor. And that is why the office of governor was But the problem is with the wording which is used in the constitution. The governor is bound by the aid and advice of the chief minister and council of ministers, except in those circumstances when the governor has to act in his discretion. What are these discretionary powers? As I told you, not clarified, not defined, not explained in the constitution. And it is the use or alleged misuse of these discretionary powers. That is why critics argue that we need to abolish the office of governor. What is this misuse of these discretionary powers? Number one, in choosing the chief minister. Constitution says the chief minister shall be appointed by the governor. And who is this chief minister going to be? That is not mentioned in the constitution. Normally, what happens if after the election a political party wins the election, gets the majority, the leader of that political party is appointed as the chief minister by the governor. But what if it is a hung assembly where no political party has the majority? This is where the governor has the discretion. The governor can appoint anyone as the chief minister. And in choosing chief minister, the governor is alleged to have been misusing his discretionary powers. How? I'll give you two examples. 2017, assembly elections were held in Karnataka. No political party got the majority, but the BJP emerged as the single largest party. But then, after the election, two other political parties decided to come together to form the government. The Congress and the JDS. They had the majority together. They approached the governor, invite us. We will form the government in Karnataka. The governor said, no, not you. I will appoint the leader of the single largest party, which is the BJP, Mr. Yediyurappa. I will swear in him as the chief minister of Karnataka. Why? Because I have a discretion. I can choose anybody as the chief minister when there is a hung assembly because no political party has the majority. But remember, the governor is appointed by the president on the advice of the prime minister, who is the leader of the ruling political party at the center, which was the BJP. And in the state of Karnataka, the leader of the BJP was appointed as the chief minister. Same year, elections were held in Goa. Again, a hung assembly, which means no political party got the majority to form the government on its own. But here, Congress emerged as the single largest party. Congress approaches the governor, invite us to form the government. The governor says no. Why? Because BJP and various other smaller political parties, they have come together to form the government. The governor said, I am not bound to invite the leader of the single largest party to form the government because I am concerned with the stability of the government. And I think the stability can be best ensured if BJP and these smaller parties would come together to form the government because they had the numbers. So, inviting leader of the single largest party in Karnataka, but inviting a post poll alliance of BJP and smaller parties in Goa, this is the misuse of the discretionary powers of the governor because the governor is now acting in favor of the ruling political party at the center because he gets appointed on the recommendations of the ruling political party at the center. Second, in testing majority. In Madhya Pradesh, Mr. Kamal Nath was the chief minister belonging to the Congress party. But then there was a rebellion. Some 20 odd MLAs rebelled against Mr. Kamal Nath. And this rebellion was led by Jyotiraditya Scindia, who was not even an MLA. Then what happened? The governor is asking the chief minister, prove your majority on the floor of the Legislative Assembly. Because it seems that if 20 MLAs have withdrawn support to you, they have resigned from your political party, which means your government is in the minority in the Legislative Assembly. Prove your majority on the floor of the Legislative Assembly. The chief minister is advising the governor, don't call the session of the Legislative Assembly now. Don't ask me to prove the majority because there is COVID-19 pandemic. The governor says, no, you have to prove your majority. And ultimately, the government of Kamal Nath collapsed in Madhya Pradesh. Something similar happened, but with a different outcome in the Rajasthan. In the Rajasthan, there was a Congress government headed by Mr. Ashok Gehlot. But his deputy, Sachin Pilot, along with some 13 MLAs, rebelled against Ashok Gehlot, and the governor thought that maybe the government has lost the majority. But this time it is the chief minister who is advising the governor that please summon the legislative assembly. I want to conduct a floor test because I have the majority. This time it is the chief minister advising the governor that I want to prove that I have the majority on the floor of the legislature. And that was very clever on part of the chief minister, because if he proves the majority today, then for the next 6 months, he is safe. That means for the next 6 months, nobody can introduce a no confidence motion against the chief minister. He wants to prove the majority now. But the governor says, no, we will not have the session of the legislature. Why? Because there is COVID. So there is COVID in Rajasthan, but there is no COVID in Madhya Pradesh. The governor misusing his discretion in asking the chief minister to test the majority. Third, in the dismissal of the chief minister, the most famous or infamous example of a Karnataka chief minister, Mr. S.R. Bommai. S.R. Bommai was the chief minister of Karnataka from the Janata Party, and then there were some conflicts within the Janata Party, and some MLAs wrote to the governor that we have withdrawn support to S.R. Bommai government. S.R. Bommai is now approaching the governor that I think I have the majority. Please allow me to prove my majority on the floor of the Legislative Assembly. Because if I have to prove the majority, I don't have to prove this majority in the Raj Bhavan. I have to prove this majority on the floor of the Legislative Assembly. The governor is saying, no, I have received the letters from various MLAs, and these MLAs have withdrawn support to you, which means you are in a minority, you have to resign. The chief minister is saying in pleading before the governor that some of these MLAs, they have written to me again, saying that they have never written this letter. Some of the MLAs who have given signature on this letter, they are saying that this signature was taken through coercion, through fraud. So they are supporting me. Please allow me to prove my majority on the floor of the legislature. The governor is saying no. The governor advises, sends the report to the president asking for the imposition of president's rule under Article 356 of the Constitution in Karnataka. Why? Because the government in Karnataka was in opposition, was led by the opposition political party, opposition to the ruling political party at this. So, in choosing the chief minister, misuse of the discretionary power, which means favoring the ruling political party at the center. In testing majority, in dismissal of the chief minister, in recommending president's rule, this is where there has been a misuse, abuse, overuse of the discretionary powers of the governor. Similarly, in dissolving the legislative assembly, for example, in Jammu and Kashmir, PDP BJP government collapsed because the BJP withdrew support to the PDP government. After that, PDP, National Conference, Congress, they decided to come together to form the government. They approached the governor that we want to form the government in Jammu and Kashmir. What governor did? Dissolved the legislative assembly even without giving them an opportunity to form the government and prove majority on the floor of the legislative assembly. In fact, hilariously, these political parties had sent a fax to the office of the governor, asking the governor, advising the governor, requesting the governor that please give us the opportunity that we want to form the government in Jammu and Kashmir. The governor said, my fax machine was not working. And ultimately, what happened? The legislative assembly was dissolved. In reserving bills for the consideration of the president, in not giving assent to the bills passed by the legislative assembly, all these are the discretionary powers used, overused, misused, hyperused by the governor. And that is why some people say it is time to abolish the office of governor. Why? Because what is constitution? Constitution is the document of people's faith and aspirations. And the main pillars of this constitution, universal adult suffrage. Everybody who is above the age of 18 has the right to vote. That is one pillar of our democracy. Similarly, parliamentary system where people will elect their MLAs. These MLAs will choose the chief minister, and this chief minister will be accountable to the public through legislative assembly. Chief minister is not accountable to governor. Chief minister and the council of ministers, they are accountable to the public in legislative assembly. Fundamental rights. All these are the expressions of those aspirations which we see in the constitution. And all these aspirations are under assault if there is a nominee of the ruling political party at the center sabotaging the governance in a state. But then there are people who say we need the office of governor. Why? Because if there is no governor, who will appoint the chief minister? If there is no governor, who will appoint the ministers on the advice of the chief minister? So we need a governor. In absence of the governor, if you are asking for advocating for the abolition of the office of governor, who will perform this role in the absence of a governor? There is a solution to that as well. What is the solution? Why can't we mention it in the constitution itself? That too clearly. What options are available in choosing the chief minister? And then reduce the swearing ceremony to a mere ceremony which will be performed by the Chief Justice of a High Court. But what are you saying? Who appoints the president or who swears in the president of India? The Chief Justice of the Supreme Court. Let's reduce the appointment of the chief minister to a mere ceremony which will be presided over by the Chief Justice of a High Court. So in Tamil Nadu, if we need to appoint the chief minister, this chief minister should be appointed by the Chief Justice of the Tamil Nadu Madras High Court. That's it. But what if there is a hung assembly? What if no political party has the majority? This is where the misuse of the discretionary powers took place. Maybe this power would then be misused by the Chief Justice of a High Court. No. Why? Because we will amend the Constitution to provide step by step guidance to the Chief Justice of a High Court that you follow these steps in choosing the Chief Minister. What are the steps? If after the election, a political party has won the election, has the majority, appoint the leader of that political party as the Chief Minister, which means there is no discretion for the Chief Justice of a High Court. What if there is no political party which is in a position to form the government? What are the steps that the Chief Justice of that High Court will have to follow? Now, listen to me carefully. Elections were held in the state of Maharashtra in 2019, and no political party got the majority. And there were four major political parties which contested this election: the BJP, the Shiv Sena, the Indian National Congress, and the Nationalist Congress Party led by Mr. Sharad Pawar. BJP and Shiv Sena contested elections together. There was a pre-poll alliance. And there was a pre-poll alliance between the Congress and the NCP. Election results were declared. No political party got the majority on its own. In this case, if one political party had got the majority, the leader of that political party will be appointed as the chief minister by the Chief Justice of the High Court. Now, if no political party has got the majority, then what the Chief Justice should do? Invite this pre-poll alliance to form the government. What if this pre-poll alliance also is not in a position to form the government? Because Shiv Sena said, the leader of our political party should be the chief minister. Mr. Uddhav Thackeray should be the chief minister. We are not going to be forming a coalition government where the BJP leader is the chief minister. In that case, invite the leader of the single largest party first to form the government. What if he is also unable to form the government? Then, post-poll alliance. Because after the election, there was an alliance between the Congress, NCP and the Shiv Sena. Then invite this post-poll alliance to form the government. And in this post-poll alliance, it may be possible that NCP and Shiv Sena will form the government and Indian National Congress will support this government from outside. That means without joining the government, without becoming ministers, Congress will support this government. Support how? If BJP introduces a no confidence motion against this government, Congress will vote against that no confidence. This should be mentioned in the constitution itself. Let's amend the constitution and say the Chief Justice of the High Court shall appoint the leader of the political party which has won the election as the Chief Minister. If that is not possible, then a pre-poll alliance, the leader of the pre-poll alliance should be given the next opportunity. If that is not possible, then the leader of the single largest party to form the government. If that is not possible, then a post-poll alliance should be invited to form the government, which leaves no room for any discretion on part of the Chief Justice of that High Court. And maybe we will solve this problem once and for all. That is why let's abolish the office of governor, make the rules of the government formation absolutely clear, crystal clear in the constitution itself, so that there is no violation of the discretionary powers available. But then there is another option, or there is another viewpoint. There are some advocates, there are some experts who say that the office of governor is indispensable. This is an office that you cannot abolish and should not abolish. This is an office which cannot be dispensed with. Why? Because let's look at the example of Manipur. A government is not possible in Manipur right now because of various reasons. There is a chaos in Manipur. In absence of a democratically elected government, who runs the administration in Manipur? Governor. In absence of governor, then who will run the state? Can we entrust this responsibility to the judiciary? Would it not be violation of the separation of powers? Because separation of powers say that executive and judiciary have to be kept separate. In absence of governor, if we abolish the office of governor, who will run the state? Who will perform the activities of that state if there is no government, if there is no governor? That is why this office is necessary. Need this office. This office is indispensable because no other constitutional functionary can discharge these responsibilities in addition to his own duties. Will the Chief Justice of a High Court give justice to the people or will run the administration of that state? And in fact, the governors of some states, they have additional responsibilities in ensuring the administration of tribal areas. The governor of some states, for example, Nagaland, have a special responsibility of ensuring law and order in Nagaland. In absence of the office of governor, if you abolish the office of governor, who will discharge these duties? Then there will be a vacuum which no other constitutional functionary would be in a position to fill. So, on one extreme, we have those experts who say abolish the office of governor. Then, on another extreme, we have those experts who say we cannot dispense with this office. Then there is a middle ground, and that is our ground. We need the office of governor, but with some reform. What are these reforms? That's something that we will. Reform suggested by Sarkaria Commission. Way back in 1980s, a commission was set up by the central government on center-state relations. And this came to be known as the Sarkaria Commission. Sarkaria Commission had a beautiful chapter on the governor. If these reforms are implemented, then we will prevent the politicization of the office of governor, and then nobody will advocate the abolition of the office of governor. What did Sarkaria Commission recommend? Number one, a person who is to be appointed as the governor of a state should satisfy this criteria. Criteria in the sense, he should be an eminent in some walk of life. For example, who do you think has been the best ever Indian president? Best ever Indian president. And I will tell you what will be your reply. APJ Abdul Kalam. Was he a politician? He was an eminent in some walk of life, the missile man of India, the real Bharat Ratna. He was the one who had his independent approach towards constitution. He was the one who sent the Office of Profit Bill back to the parliament for reconsideration. He was the one who was most loud Indian president ever. and he was not a politician, but he was eminent in some walk of life. If we will appoint people of similar stature as the governor of a state, this governor will not be acting on the diktats of the ruling political party at the center. And then the relationship between the chief minister and the governor would be beautiful. That's what Sarkaria Commission recommended, that this governor should be eminent in some walk of life. Unfortunately, that is not the case. A study was conducted by Professor Ashok Pankaj on India's governors since 1950 to 2015. 52% of the governors appointed are politicians or retired bureaucrats. 26% are retired bureaucrats, 52% are politicians. Politicians are retired politicians. This Raj Bhavan, which is the official residence of the governor, is now like a retirement home for retired politicians. Remaining ones are judges, lawyers, defense officials, academicians. One fifth of the governors were former MPs or legislators. So clearly, we have not been following the recommendations of the Sarkaria Commission. In fact, Mr. Shekhar Gupta, who is the editor of the print, he says this office is generally an abomination, disgusting office. And if this office disappears one day, nothing will happen. But we need to pay heed to the recommendations of the Sarkaria Commission. Appoint somebody who is eminent in some walk of life, maybe art, literature, science, social service. He should be a person from outside the state. So you should not be appointing the resident of a state as the governor of that state, because then he will get involved in the day-to-day activities of the government. And then there will be a clash between the appointed governor and the elected chief minister and the ministers. Don't do that. It is advised that you appoint someone as the governor who is from outside the state. And he should be a detached political figure, not too intimately connected with the local politics. Why do we need politicians appointed as the governors? Appoint somebody who is detached from politics, from local politics of that state. He should be a person who has not taken great part in politics generally, and most importantly, in the recent past. Maybe we can appoint a politician as the governor, but this politician should have been an ex politician. Maybe he was active in politics 5, 6, 7 years ago. Now he is a detached political figure. You can appoint him as the governor, because we have to depoliticize the office of the governor. It is desirable. This is the most important recommendation. It is desirable that the member of the ruling party at the center should not be appointed as the governor of a state which is ruled by the opposition. For example, have you heard that there is a conflict between the chief minister and governor in UP or Madhya Pradesh now, or Chhattisgarh now, or Rajasthan now? No. Why? Because the ruling political party appoints its members or its member as the governor, and the government there is run by the same political party. So there is no conflict. The conflict we see whenever the ruling political party appoints its member as the governor in a state which is ruled by the opposition. And that is what Sarkaria Commission warned us again. There has to be consultation with the chief minister. You don't have to agree to what the chief minister is saying, but at least present 3, 4, 5 names to the chief minister. Consult the chief minister that these are 5 names on our mind. Please tell us, what is your take on these 5 names? And maybe we can agree that this particular person should be appointed as the governor of your state. So consult the chief minister. And this consultation with the chief minister should be prescribed in the constitution itself when we will amend Article 150. But do you know what is the biggest problem with the office of governor? Security of tenure. Why governors are doing the bidding of the ruling political party in the state? Because if I am appointed as the governor, I don't have the security of tenure. In a sense, although I am appointed by the governor for a period of, I am appointed as the governor by the president for a period of 5 years, but I hold this office during the pleasure of the president. which means at any point in time, I can be removed by the president on the advice of the prime minister. I can be sacked. I can be transferred to another state. So I don't have security in tenure. If I have the security that for 5 years I will not be touched, I will not bow down to the diktats of the ruling political party at the center. So give me this security. Mention it in the constitution that the term of the governor is 5 years and remove this phrase subject to the doctrine of pleasure of the president. That will go a long way in ensuring that we depoliticize this office of governor. An exhaustive study called Heads Held High, Salvaging State Governors for 21st Century. This study was conducted by India's prominent think tank, Vidhi Center for Legal Policy. This think tank suggests that we should not abolish the office of governor, we should rather reform it. One of India's top lawyers, Mr. K. Viswanathan, he says, problem is not with the office of governor. Problem is with the person who occupies this office. So if the person is doing something wrong, that does not mean that there is a problem with the office. Reform this office so that we can depoliticize this office. And what is recommended? Don't abolish this office. Let sunlight in. What does that mean? Sunlight is the best disinfectant. If there is a problem because of opacity, let sunlight in. Let there be transparency. Transparency in the sense, record the reasons for a governor's action. If the governor is not giving assent to bills, he has to necessarily record reasons, mention reasons. Why am I not signing this? If I am not summoning the Legislative Assembly, record reasons. Why? If I am doing this and not doing this, record reasons. Why? Because if there is transparency, there will be debate. There will be accountability as well. So then we can question the governor. Why are you doing this? This is not the reason you should be doing this. So instead of completely abolishing this office, what we need to reform this office. How? By paying heed to the recommendations of the Sarkaria Commission and by ensuring that sunlight is in. Record reasons for your actions or inactions. And this is something which has been recommended by the Punchi Commission as well, headed by former Judge Madan Mohan Punchi. In 2007, Punchi Commission had recommended that if you are appointing someone as the governor, this governor should have stayed away from politics, even at the local level, for at least 2 years prior to the appointment. Which means if I'm a politician right now, but now I have detached myself from politics, I'm not organizing rallies, I'm not contesting elections, and if I'm a detached political figure for 2 years, then I should be eligible to be appointed as a governor. Because the problem is, when active politicians are appointed as governors, their DNA is politics, and they will play politics with the democratically elected government. Second, echoing the recommendations of the Sarkaria Commission, Punchi Commission said there has to be the say of the chief minister of the state in appointing the governor. And maybe set up a committee. Instead of president appointing the governor on the advice of the prime minister, there has to be a committee which should recommend names to the president for appointment. This committee should have prime minister, home minister, Lok Sabha speaker, and the chief minister of that state. But now you will say, sir, even the composition of this committee is tilted in favor of the ruling political party. But right now, when a governor is appointed by the president, we don't know why this governor was appointed, for what reason, on the basis of what criteria. But if there is a committee which is discussing few names, the committee will record reasons why we are appointing this person, why we are recommending this person. More sunlight, more transparency, people will get to know. And when chief minister of that state will be part of this committee, he will mention it in the reasons why I am objecting to this name. So more debate, more discussion, thorough examination of these in good of the larger democratic politics of. Punchi Commission said this doctrine of pleasure should be removed from the Constitution. What is this doctrine of pleasure? Constitution says the office of the governor, the tenure is for 5 years, but that is subject to the pleasure of the president. Which means even before 5 years, the president may remove you, the president may transfer you. This should be removed because this doctrine of pleasure is like the Damocles sword hanging atop the head of the governor, who will have to do the bidding of the ruling political party at the center. Otherwise, he will be removed. Remove this doctrine of pleasure and make it clear that the term of the governor is 5 years. And if you want this governor to be removed, the governor can be removed just like the president is impeached by the parliament. If a governor is blocking bills without reasons, interfering in the administration of the state without reasons, blocking the governance of that state, the legislature of that state could pass a resolution removing the governor, recommended by the Punchi. And you may also have heard or read about governors acting as the chancellors of state universities. This is the bone of contention between the Tamil Nadu governor and the chief minister. The Tamil Nadu legislature passed various bills to remove the governor as the chancellor of various universities. Punchi Commission said this convention, that governor is the chancellor of state universities, we should ensure that this convention comes to an end. Why? Because governor should only have a constitutional role to play. He should not be involved in other roles and functions, such as being the chancellor of the state university. No, this convention has to come to an end. Although it is not a convention, although it is mentioned in the Punchi Commission, it is basically the governor is the chancellor of various state universities according to the laws passed by the state legislature. So it's not a convention. What have we understood in this video? What is the function, role of the governor, and how the discretionary powers have been misused or allegedly hyperused by the governors? For that, there are three options. One, abolish the office of governor. We don't need it. Second, we need the office of governor without any reforms because this office is indispensable. Third, much better solution is don't dispense with the office, but reform it based on the recommendations of the Sarkaria Commission, based on the recommendations of the Punchi Commission. And that will go a long way in depoliticizing the office of governor, will ensure parliamentary democracy in this country, and will ensure that people's voice is respected. Thank you for watching. Do let me know in the comment section what is your take on the office of governor. Bye bye. Take care.